Officer Dave, would you open my courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. We are on the record calling for pretrial, case number 20160-566. Open MRI of Livonia versus the Hanover Insurance Company, Citizens Insurance Companies, your respective appearances.
Good morning, Your Honor. Arnold Reed on behalf of the plaintiff, P84142.
Good morning, Your Honor. Matt Ragg on behalf of the defendants, P67545.
Okay. I have the disclosures. I'm sorry, we were last together on February 22nd, and at that time, it appears that nobody had done the disclosures. Since then, I have disclosures sent over by the plaintiff. Defendant, have you made your 2.3028 disclosures?
Yes, Your Honor.
Okay, you have those, Mr. Reed?
I believe I do have those, Your Honor.
Then where are we on resolution, gentlemen?
So, Your Honor, we're still at the same kind of place that we were at last time we appeared before you. We've given defense counsel an offer, and I don't think we've received a response regarding that offer, but we know where we stand with this case, and if we can't get this resolved, we're prepared to move forward.
Mr. Reddick, what's going on?
Your Honor, since the last time we were here on the 22nd, both sides have exchanged written discovery. Plaintiff's discovery requests are due in a couple of days now, and defendants are due a little after that. So there's been no discovery. I'm sorry.
Okay, so you guys are doing discovery by stipulation. Is that right?
It would appear so, Your Honor. I don't have
Well, here's the thing. The only thing I authorized were the 2.3028 disclosures. If you guys want to do discovery, you certainly can do it by stipulation. I have no problem with that. So if that's what you're doing, that's fine. That's fine. So let's do this then. Let's get you another date and you can continue on with your stipulated discovery.
Thank you.
April 26th, work for both of you?
Yes, Your Honor. I'm assuming at 10 a.m.
It will be at 10 a.m. Yes, sir.
That works for defendants.
That works for you too?
Yes.
Okay. So what I'll do is I will just send you a notice, April 26th. (10 a.m.) And I'll note the disclosures have been made. Parties conducting discovery by stipulation. Is there anything else we can accomplish today, gentlemen?
Nothing.
All right, well, let's get this discovery that you guys have decided you're going to do. Let's get it done. So we can get moving forward on this thing, okay?
Sounds good.
All right, gentlemen, we'll send out an order. Thank you for coming in. Be safe. We're off the record.
Take care.
Take care.
Have a good day.
You as well.
Ms. Stoller?
Hello, how are you, Judge?
I'm not bad. How you doing?
I'm good, thank you. And I know Mr. Lebenbaum, we have on this case as well. And I think,
Okay, this is the Silver Pine matter?
yes,
Okay, so I think we have everybody there on that one. Then hang on, let me get them in here as well.
thank you so much.
All right. It appears that I have everybody now on file number 191828833. Silver Pine Imaging versus City of Detroit, your respective appearances.
Your Honor, Stuart Levenbaum here on behalf of plaintiff,
Our number.
P42879.
Good morning, Your Honor. Kara Stoller. I am also here on behalf of plaintiff P64540.
Morning, Your Honor. Teresa Oled, P72765, appearing on behalf of defendant, City of Detroit.
All right, just so the record is clear, as I understand it, Mr. Levenbaum's appearance is limited to the issue of attorney fees.
That's correct.
Correct.
Okay, so let's leave that aside for now. Talking to Ms. Stoller and Ms. Ouellette, where are we on our discovery? Are we done?
I
Yes,
believe,
Your Honor.
I'm
believe
sorry.
so, Your Honor.
I see your lips, but I didn't get a sound.
Yes, we are done. This case has been pending for obviously some time
Yes.
because of COVID pandemic. I know that we were discussing resolution, but unfortunately we have not resolved the case.
All right, Ms. Ouellette,
That is correct, Your Honor. We've had some settlement discussions, but we are just, we cannot come together on a settlement on this one.
sure you can. The amount of money at issue is finite. You have I'll just say this charitably, a protocol. You typically pay X amount of bills. They have a protocol. They typically accept Y amount of bills. This is a mathematical exercise. This ain't hard. This ain't brain surgery. Let's get it done. Now, I'm going to give you guys another pretrial date, and then I'm going to cut Ms. Stoller loose because she's not involved in this attorney fee fight. Does April 26th work for both of you guys?
Yes, Your Honor.
Ms. Ouellette,
I'm just checking my calendar.
take your time.
Thank you.
I'm here all week.
I have a, if it's at 9, that would work, but I have a case evaluation at 10:15.
And that's not going to work. This case, now, let me ask you this. Do you do case evaluations in person or are they remote also?
They've been via Zoom.
Okay. So you're going to be sitting in the same place anyway.
That's correct.
All right, well, let's do this. How about we take you guys to April 26th at 11. Does that work for everybody?
Yes, Your Honor.
Yes, Your Honor.
All right, we'll do that. And your discovery is now closed. All right, that's now. We move to the issue of attorney fees. Long, long ago, court entered an order granting attorney fees in this file. And it looks like my order was entered, excuse me, I granted it. I didn't enter an order. On the 20,
Judge, my records are November 17th, 2020.
November 17th, right.
And Your Honor, at the last pretrial conference, you told plaintiff's office that if they did not submit an order for your signature, that they would be waived.
But Mr. Levenbaum says he submitted an order.
Actually, twice we submitted the order, Judge.
Here's what I'm gonna have to take your word as an officer of the court. I don't have it. So here's what you're going to do today. You're going to send out by snail mail a 7-day order for those attorney fees.
That's fine.
And that way I can go ahead and enter because I don't know what's going on or what's not, but I can tell you that my file does not reflect the two filings that you say you have made concerning this.
But
Now-
both of which were done electronically, Your Honor, and I know that this is kind of a new process for the 36th District Court. I
What?
will tell you, they were able to take my filing fee electronically.
They may very well have done so.
Yeah.
But I don't have it on my register of action.
All right,
I have nothing to indicate that that has occurred.
okay.
So when we're together the next time, April 26th at 11, one or two things will happen. By that time, I either will have entered the 7-day order for attorney fee, or you may take the matter up on appeal
Okay,
because I will deem them to have been waived.
okay, fair enough.
Everybody clear on that?
Yeah, I mean, the other option is, Judge, is you got those blank order forms. You could just write, it's hereby ordered, defendant shall pay $2,610 to plaintiffs.
Well, the problem with that
Yeah.
is that Ms. Oulette may choose to object to the order. And by doing it that way,
Yeah.
she loses her opportunity that she has under the 7-day rule
Okay,
to file an objection and have a hearing.
no problem, Judge. I'll put it in the mail today.
Wise decision. April 26th at 11 o'clock.
Thank you, Your Honor.
In the meantime,
Yeah.
Ms. Stoller and Ms. Oulette, this is a PIP case like any other. Neither one of you is going to get what you want. You're doomed to be unhappy. The only thing we're talking about is when you become unhappy. Since we know how it's coming out, let's get it done. Let's get it done. Because the likelihood of a trial in the 36th District Court in a civil case in the reasonable future is, I'd say charitably, slim and none. And Slim left town. Okay? I mean, it's just not gonna happen. So the file goes old. And the interesting thing about this, we used to have case resolution guidelines. They wanted you to resolve a certain amount of cases by a certain amount of time, right? Obviously, that had to go out the window with the advent of COVID. So if the case is a year for another year, another 2 years, it makes me absolutely no difference.
Yeah, the judges must hate that.
It's really a pain. It really is a pain because
I'm saying it facetiously, Judge. You guys must not mind the Supreme Court Administrator's Office not bearing down your throats anymore.
we try to move files.
Yeah,
Yeah, they can't move them. That's what I would
Can't
assume.
move. See, I can't, I used to be able to resolve files by saying, y'all gonna come in, we're gonna have a settlement conference
right.
and you will be physically present. Well, I can't order people to be physically present now. We're not letting folks into the building.
Right.
So what I'm doing is I'm threatening with an empty gun and everybody knows my gun is empty. Now, when I can make that happen, come on down, let's have a settlement conference. Let's sit around for a couple of hours and see what you think about it. Oh, we didn't get it done today. Let's try it again. Somewhere around the second or third settlement conference, click, the light goes on. This guy's gonna have me come back here till the case is settled or until I retire, one or the other. At that point in time, we get settlement resolutions. But right now, everybody knows I can't do that. And I can't even say, hey, I don't want to do this like some of my colleagues. Oh, but the Supreme Court is making me do it because of my case guidelines. Because everybody knows we don't have case guidelines. And as long as you can sit in your offices, don't have to get dressed, don't have to come down here and pay to park, deal with security, get on the elevator, and all that, sit around my courtroom, listen to me talk to other people about things you could care less about. It's much more difficult to, what's a charitable word? Encourage settlement. So that's my dilemma, and I have to live with it. April 26th at 11 o'clock, your order, Mr. Lettenbaum, or it'll be nice talking to you on appeal.
All right, Judge.
Thank you, everybody.
Thank
Y'all
you.
have a good day.
Thank you.
If the
You
case
too.
is resolved, that's where we're going anyway. That's where we're going anyway. Because at some point, I'm going to be able to have settlement conferences again. And by that time, it'll probably be cold outside. So I'm talking about come on down and drive in the ice and snow and put on all your big clothes and slosh around in ice and snow. It's not like it's nice now. Y'all have a good day.
Thanks, Judge.
Okay, we're off
Thank
the record.
you.
Mr. Hiltner, I don't have an opponent for you yet. Have you guys for a chance settled your case?
No, we have not settled this case.
Okay, well then, I'll put you back in my waiting room and we'll give her another 12 minutes.
Okay.
Thank
Your
you,
Honor.
sir. It's gonna be dismissed, so don't have to worry about it. We are on the record calling file number 20160-337. This file is entitled Focus Imaging versus City of Detroit. By a notice dated February 22nd, 2021, this matter is scheduled for pretrial today, March 22nd at 10 a.m. This date and time was agreed on by the parties. It's now 10:32. Your appearance. Your appearance, counsel.
Yes, Your Honor. Philip Hildner for defendant, City of Detroit, P77913.
All right, we don't have a defendant here. We have a defendant, excuse me, we do not have a plaintiff. My file contains your motion to consolidate Mr. Hildner, but given the failure of plaintiff to appear, your motion is not going to be decided. Instead, plaintiff having failed to appear, no good cause of that failure having been shown, this case is dismissed without prejudice. We are now off the record. Have a good
Thank
day.
you, Your Honor. Yes,
Thank you for coming.
you too, Your Honor.
Can't fail to appear. not in 5 days. Good morning.
Morning.
What file do you have?
This is ADLP versus Hawkins 2165-429.
Okay. I think I have Mr. Hawkins. I thought I saw him a minute ago.
Okay.
Let's get him in here.
Hello?
Hello.
Hello. Okay. I have another case before you, gentlemen. Hang on. Put you back into the waiting room. Here's Mr. Hawkins.
Okay.
We are on the record calling file number 20165-429, ADLP Investments versus Deshaun Hawkins. Date and time for pretrial, your respective appearances.
Good morning. Robin Stradowski on behalf of ADLP, key number 71195.
And what is your name, sir?
Deshaun Hawkins.
All right. The court entered an order on February 9th, 2021, setting up our March 9th pretrial. In that order, defendant was to file his answer within 14 days. We had our pretrial on March 9th, and the defendant had still not filed an answer. Court entered to set the matter for pretrial today and ordered defendant shall file and serve his answer by March 19th, or the court will enter a default judgment. Did you file and serve your answer, sir?
Yes, sir, I did.
When?
On the 19th.
Where did you file it? Because I checked just now and there's no register of action.
I've got a fax. I don't know if you can see this. I have a fax confirmation from the UPS store. It was sent on the 19th.
Ms. Zdrowski, do you have that?
We do not.
Did you serve a copy of the other side?
I did not. I sent it directly to the 36th District Court.
This is the court's order. I'm reading from it now. Defendant shall file and serve his answer. If you didn't serve the other side, you didn't follow the court's order. This is the court's ruling. Having failed to file the answer and serve the answer, having been given an extension, the court will enter default judgment. Mr. Zdrowski has previously submitted a default judgment. I will enter that judgment today. You have failed to comply with the court's order despite being given an extension. You have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. Thank you both for coming in. We are now off the record.
Thank you.
We are on the record calling case number 20142-972, Melton Haygood versus Richard Clay. Your appearances.
Oh, Richard Clay, sir.
Melton Haygood.
All right. We were last together on February 22nd.
Yes, sir.
And I got a partial transcript from the defendant in this matter. in relationship to a case entitled Richard Clay versus Melton Haygood, 36th District Court landlord tenant case, that file number 203438689. And in that case, apparently in that landlord tenant case, Mr. Haygood, you were represented by counsel, correct? A Gerald Featherston.
Yes, sir.
All right. In that case, reading from page 10 and 11 of that transcript, your attorney indicated that there was no retaliation because when he looked into the documents, my client received the notice before he filed his general civil suit. So what I'm going to do, I'm going to strike, based upon your attorney's admission, a portion of your complaint, and that would be paragraph 5 of your complaint, your attorney having admitted that there was no harassment. Now, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days today in the Wayne County Circuit Court. Let me urge you gentlemen again, you both need counsel. The court operates under a set of rules, which clearly neither of you know. And both of you are at a disadvantage because of that. Let me urge you again, get counsel. I take it you're not ready to resolve this matter?
No, sir.
So be it. All right, I'll send out my order. I'll give you a new date.
Thank you, sir.
Our next day, sir, will be May the 17th at 11 o'clock. Does that work for everybody?
Is this for the appeal, sir?
This is I'm sorry?
Is this for the appeal, or do I have to
No,
go
sir,
down?
your appeal, if you choose to appeal, sir, you appeal to the Wayne County Circuit Court.
That's where I want to appeal. So I go down to Wayne County and appeal it?
Yes, sir. You have to,
Okay.
I'll send out my order today.
Good.
So May 17th work for everybody?
Yes.
Mr. Hager?
I'm looking now, sir. May 17th, you say, sir?
Yes, sir.
Okay. Yes, sir, that works. At 11 o'clock?
Yes, sir. May 17th, 11 o'clock.
So, Your Honor, can I just ask the court to please dismiss this case, sir?
Sir, I don't know how many times I can tell you. The court operates under a set of rules. If you
Yes,
want to file a written motion to do so, you may file any motion you want. You don't just say, this ain't small claims. I have told you gentlemen that as many times as I can. I don't know how much more clearly I can say it. You must follow the Michigan court rules. If you choose to represent yourself, as is your constitutional right, you have to follow the Michigan court rules. This is not small claims.
I got you.
Let me urge you again, both of
Yes,
you,
sir.
both of you need counsel. You'll get 2 orders. There'll be an order striking paragraph 5 of the complaint based upon the admission of Mr. Hagood's counsel at the previous matter. And I'll see you gentlemen again, May 17th at 11 o'clock.
Thank you, sir.
Urge you again, you gentlemen both need lawyers. We're off the record. Thank you for coming in.